January, they sort of look over their rules for the year and they sort of decide what they should do and what things should be improved upon, or things just to remind things like civility and the code of ethics. And so I recommend to you that you look at the Hanover Board of Supervisors handbook. It is 26 pages long, but it has standing rules and procedures, and it's one of the best ones out there. They redo it every year. I only brought one copy, but I'm happy to leave it here. But it really is something you can pick and choose the things that you want to use for your council and for your EDA and how you move forward with your rules and things like that. So something I would just recommend that you think about looking at. VML on our website, it's vml.org. We have a code of ethics, or a code of civility. So one of the things we've been really working on the last couple of years at our annual conference is having speaker Matt Lehrman come and talk about civility in different ways and how we learn to work together and try to really be successful, even though sometimes we don't always agree on things. So something else to think about adopting. And then the last thing is the code of ethics. I have the Abington one here. Again, I have one copy. I can leave it here, but there's many other code of ethics out there, but it just sort of sets out sort of how we're going to treat each other and also how we're going to treat the public, right? Because you get that person in the public that's screaming or yelling or something. And so it's really important to have those, sort of those rules out there so everyone's aware of what they are. And I recommend that you look at it every year just to sort of remind everybody of the rules that you've agreed upon. So the other things we have, I gave you our 2024 legislative program. That's something that we create every year. And it's really VML's guide on what we do during the General Assembly, what we lobby on and what we don't. And it comes out of 5 policy committees and a legislative committee that are all made up of local elected officials and some managers. So if you're interested in doing that next year, the notice comes to the clerk sometime in March, but please feel free to sign up for one of those committees. They meet via Zoom. So it's one time in the summer that they meet. So it's not a huge commitment. If the legislative committee meets 3 times, but the other committees meet once. So it's not a huge commitment. So just something to look at. And then lastly, I gave you both the FOIA slides and the FOIA and COIA conflict of interest book. We have a bunch more books there. So if you want to take them, please do. We update this every July so that you know what the rules are each year, but it's a great handbook just to sort of look up the rules as you're sitting in a council meeting or you have a lot of questions. So I thought I'd start with the Freedom of Information Act, if that's okay. And I'm going to go through the slide deck, but I'm not going to read every slide and I'm not going to talk too much about every slide. What's really important about the Freedom of Information Act is we all think about it as how do we hide the records, right? I mean, it's sort of our gut feeling is what records can we take away or what records should we not show the public? But that's not really what it's designed for. As it says in the basic purpose is it's really intended to be everything is open and then we funnel down what we decide is not open to the public. So we have to think about it from the standpoint of everything that we write, everything that we do. Reminder, it means text messages too, Snapchat, whatever other, things that we use, right? So again, whenever there's a doubt, you should keep in mind that the favor is openness and transparency. So there's 2 parts of FOIA that we're going to talk about. One is meetings and one is public records, because they're 2 sort of separate things that you have to think about when you're dealing with the transaction of public business. And I will tell you, in here, there's a couple of cases we're going to go over, but there's a bunch of proposed legislation out there. Don't look at it yet, but they are trying to define the transaction of public business, which is really complicated and it's been fought about all summer. So don't worry about any of the things that you see in the news or anything about that yet, because it's going to be fought through the General Assembly session. So the first thing is that public body is such a broad term. It means legislative body, authority, board, bureau, commission. If you create a subcommittee of 3 people and they have something to do with public business, they're a public body. It's a really broad definition. And so you have to be really careful when you think you're being slick and saying, okay, I'm going to create the subcommittee of 2. If they're doing business of the committee in their subcommittee, then you still have to do minutes and they're a public body. So you have to follow the rules as we go through the rules. So again, there are many exemptions to public records, right? But we start out with everything's open to the public. And what you have to remember is when someone makes a request, they can make a request any way they want. They can say it to you, they can write it to you, they can say, on the street, I would just like to see that record. That's a FOIA request, right? You have to think about it that way. And you can't ask them why. So you can't really care why they want the record. And that's one of the most frustrating parts, right? Is you're like, why would they want that record? It's really strange. But you can't look into their history of why they want the record. And I'll tell you a funny story because this is why these records can be scary. We have a locality a couple of years ago, and one of the employees was allegedly having an affair with another employee. Well, the spouse FOIA'd both of their time off. And so we gave it to them and we all knew why, but that's the kind of stuff like you don't have a choice. You had to turn it over, but you knew where it was going to go from there. Didn't go well. So just something to keep in mind. You really can't care, unfortunately. And so then what records are public? Again, we've talked about this, all records, doesn't matter if it's voicemail, text message, Snapchat, regular written records, computer records. It's just everything that you can possibly think of. The basic requirements for disclosure are, as you know, you have 5 business days to respond. If you have a reason why you can extend it, you can ask for an additional 7 business days. So realistically, if you need 12 business days, you can get it. Beyond that, you either have to go to the court or you have to make a bargain with the person who made the request. And most of the time, if it's a huge request, they understand that it's going to be more than 12 business days, but you do have to have that conversation. And I would document it, obviously, in writing to say that you had agreed on a longer term to disclose those records. And you have to disclose all the records unless there's an exemption that exists. So this is another part that's funny because you have to redact a piece if it's redactable. So one of the senators a couple of years ago wanted the death penalty manual. Kind of a scary document, right? And so they fought about it, and the Department of Corrections tried to redact it. Finally, they redacted everything but the first page. And so they still got the record. So he still was the right FOIA response, but maybe not pretty, right? It was all blacked out except for the first page. So you have to sort of do those kinds of things as you look through the records and what pieces you can give over and what pieces you can't. If you're going to withhold, yeah. So there's a code, we're going to go through some of the code sections, but there's about 33 different things that you can redact. Personal phone numbers, email addresses, anything legal. There's a bunch of reasons why you can redact things. When you do that, you have to cite the specific code section. And so that's the hard part, is you have to spend the time to go through and say, this section is being redacted because it is, Jane Doe's phone number and private email. So you have to find that code section. And the next one might be a health or health comment or something. And then you have to find that code section. So you have to be really specific and list every code section as to why you're redacting the record. Or if you're withholding it, same thing. If you're going to withhold a record, you have to say we're withholding it pursuant to whatever the code section is. And so you have to actually go through and determine that. And all the code sections are in this book. Unfortunately, it's not fun reading, but it's there. So the other piece is there's a lot of the exemptions that are discretionary. So my example about the 2 personnel records, that was a discretionary section. We didn't have to give over personnel records, but we had done it before 4 or 5 times. And so we had a precedent, right? And so you can't all of a sudden say, oh, we know why this one, so we're not going to do that. So you have to be really careful about, if they're discretionary, making a determination on what you're going to do going forward, because you don't want to set a bad precedent if you give over discretionary records. And I think that's really hard because if you document that, right, it's a FOIA-able record. So you can't really, you have to think about whether or not you want to make that determination to document that record. You're not required to create a new record. And that's one of the pieces that I think is also people forget. So if they say to me, I want a spreadsheet of all the employees, and you don't have it, you might have a spreadsheet with, half of them or one department. You don't have to create a new record for that. If you have the various records, you could say, I could give you, the 5 pages with the different departments on it or whatever it looks like, but you don't have to sit down and create a new spreadsheet or create a new record to turn over. In the costs are the heart. So the costs are the next part. And let me just say that the General Assembly continues every year to fight about the costs, because we have some localities that use the cost to try to deter people from making requests. I mean, we have one town, and this is another, I'll interject stories because it makes it entertaining, right? I have one town that the poor lady, she's a part-time clerk. This lady comes in and makes a FOIA request every day. So finally, what I told her to do, she got in trouble for the charges. There were questions about was she charging fairly or not. And so in the end, what she did was she then had the police officer come every time the lady came in, and then she stopped making the FOIA requests. But that was the way to deter her. The fines weren't working. So I said, well, then get a police officer to sit in there with you. Maybe that'll, make her think about her requests more often. So because you're only allowed to charge the actual cost that incurred. You can charge the cost of the light and the cost of the copier and the cost of the paper, but good luck figuring that out. And the General Assembly members always think our fees are too high. It's constant fight with them. Delegate Rome, who now Senator Rome, she continues to try to make sure that FOIA requests are free. We argue with her what the cost to the locality is. It's the time of the clerk, the time of the person, the time and the cost of the records. But there continues to be a fight with her particularly. And I had another delegate yesterday ask me about it. So this is just something that you need to be really mindful of and come up with what your formula or what your rules are going to be. You actually now have to post them on your website. And that's just a whole nother thing because I don't really think you can post an exact cost. You're actually going to have to say it's this administrative cost between, whatever the numbers are and this potential paper cost or whatever. It's going to have to be a very vague sort of posting of those costs because we can't be exact. It's just not something that we can do depending on what the record request is. Last year, Delegate Rome, she was Delegate Rome at the time. She came in and she had this bill where she was upset that Prince William County could take electronic payments for water and sewer, but they wouldn't take electronic payments for FOIA, which seems really weird, but apparently their system just didn't work. So now the code says that you may take electronic payment, which I think we all probably could anyway. But that's our newest law, what you'll see in the red on your paper. If you think it's a big request and you think it's going to be over $200 or it's going to be onerous to the requester, you should write them and say, here's what I think it's going to cost, or here's what I think is going to happen. And you can ask for $200. If it's $200 or more, you can ask for that money up front. So then you know that you're going to get the request. Now, here's the problem with that. So I had a locality that was asked for some water and sewer rates a couple of months ago, and it was a complicated formula that their engineer did. And they wrote the requester back and said, okay, it's going to be over $200. Well, they started filling the request. So by the time he agreed to pay the money, he knew they had finished the request. So he waited a month and asked again, and then he got the record for free. So don't start the request if it's $200 or more until they actually pay the money. And the good thing about that is if you don't receive a response from them in 30 days, you can assume that request is gone and then it starts again. So you can go back and start it again. The requester also can come to you and ask for an estimate, and then you do have to apply that. You have to provide that estimate to them so they can determine what they think the cost might be. Again, the $200, the time to respond if you ask for the $200, the time clock doesn't start until the $200 check comes in. So if it comes in on Friday, your days really don't start till Monday. So you can toll the time of the 5 and 7 days until you get the money. And then the other sort of carrot that you have is if they have a prior FOIA request they haven't paid for, you don't have to fill their new one until they pay the prior one. So you can make sure that they're up to date all the time when they make these different requests. Now, this is where it gets complicated. So sometimes you're going to get a request and you know that you don't have it, but you know that the county might have it, right? Or the state might have it. And there is nothing in here that says you have to tell them where to go to get it. But really the right thing to do obviously is to say, hey, we know the county has it, or we know the state has it, or whatever, and tell them to go get it. But there is no obligation for you to do that. It's the right thing to do, but that's a decision that you have to make based upon the requests. All right, so here's your exemptions for disclosure. I'm going to go through some of the exemptions. The first one is the written advice of legal counsel and other records protected by attorney-client privilege. This is a tough one too, because sometimes you're going to want to put that information out to the public. If you think that you're going to be in some sort of litigation or something, you might want to get ahead of it and and put out the legal counsel memo or something like that. Or if it's something about the legality of an ordinance, you might want to put it out there. So you really have to talk about that one and make a decision on whether or not you want to disclose that record or not. The second one is working papers of the chief executive officer, which would be Matt in your case. If he has records that he keeps to himself, which might be, sort of the policies on discretionary records and things, he can claim the exemption for that. Now I'm going to tell you that that exemption is going to go away quickly. There's 2 bills already filed that will try to take that exemption away. They're very upset that the governor claimed a bunch of exemptions this year that people didn't think were appropriate. So we'll see where that one goes. But for right now, he has the ability to say, this is record is for my personal use and I'm not going to turn it over to you. If you have records recorded or compiled exclusively for use in closed meetings, you don't have to turn those over. So if you have, for example, a lot of closed meetings include like changes in personnel, and you do a new personnel chart and you only use it in the closed session because you haven't made those changes yet, that can be kept private and redacted or exempted from disclosure to someone. Personnel records, you can exempt as well, but employees can always see their own records. So you have to remember that if an employee makes the request, they can see their record. If their wife makes the request, no. But the employee, if they make the request, they can see the record. Yeah.
So how does that fit with the story that you told about the 2 employees' vacation time? Is that different from, is vacation time not a personnel record?
It's not. So personnel records are your name, date of birth, your address, home address, disciplinary action, but your salary, your rank, your time off, your benefits, all public information. And you can ask by name, like you could say, what's Jane Doe's salary information, and they have to give it to you. Yeah, and they may not do it by name, they may do it by position, but it's the same thing because you know who they are. Yeah.
The working papers of the chief executive, are they all the working papers or only specific ones?
It's all his working papers, but they're papers that he shouldn't share. So if it's something that he shows you and he says, this is my, this is my proposed chart, but he hasn't done anything with it yet, it's his working paper. But if he gives you a copy, then it's FOIAble. So he can talk about it. He can use it for his, like if he's giving a presentation in closed session about something, he could use it for that. But then it goes, once he shares it with you, it becomes a public record. Yep. Yep, exactly. That's right. Yep.
Since you mentioned closed sessions, I had a question about that. We do not have to keep records of a closed session.
You should not keep records of closed session.
And what's said in a closed session should stay in a closed session.
So here's the rub, and we'll talk about it again, but yes, no, but it's okay, because it's an important point. So technically in the law, there's nothing that keeps you from not disclosing what happens in closed session, which is the dumbest thing ever. That's my personal side. But the code of ethics is where you say you agree as a council or as a group that you're not going to disclose what happens in closed session. And that's where you can say to someone who does, hey, we agreed to this. Every January we sign this. That's why I started with this. Every January you sign this form and it says we're going to keep closed session private. And that's how you make sure that you all follow the rules on that particular thing.
What if you have people who won't sign the code of ethics?
Yeah, that's always the problem, because you can't, there's not much you can do other than say to them, we really expect you to do this. Or you say, you know what, we're not voting in closed session and we have a quorum, you can't come. But that's a board decision or a council decision. I mean, you can try to exclude them. Not really the right way to do it, but that's how you get around it, quite frankly. Yep. So one of the other things that you can't disclose is criminal investigation files. If your police chief has files, I'm sure he's talking to Eric Gregory, who's your attorney, about that, because those files are complicated. Giving over any police information is really a complicated issue. And so Eric definitely should be contacted on that particular issue. And again, like we talked before, employee positions and salaries always are subject to the public. It's the name, position, job classification, and salary, records of allowances or reimbursements, any official or employee earning more than $10,000. So those are all non-exempt records. Now, we had this really strange case out of South Hill a couple of years ago. And it's, they finally gotten through the case now, and here's what the case says. The Supreme Court created a new test for producing personnel records. So to your point, they said the court held that data, facts, and statements are private if their disclosure would constitute an unwarranted invasion of personal privacy to a reasonable person. We have no idea what that means, quite frankly. But what we think it means is that the personnel exemption is very narrow and that each requested document has to be reviewed separately. And so this case was a real fight. I mean, this personnel matter had gone on for years, and you have to just really look at every record and decide whether or not it's truly a personnel record where it's the disclosure of unwanted invasion of personal privacy. And that's, that's a guess every time we do it until we get to get some more clarity on that issue. And so I'm going to go to meetings, but I'm going to talk about this case first. So there was a case called Gloss versus Wheeler. And here's what happened. This is my soapbox on this case. This case was a case that was decided a couple of months ago by the Supreme Court. Local government has had several Supreme Court cases go really bad for us this last year, particularly in the FOIA realm. And so there's a lot of chatter out there about trying to fix them. But this one I think is sort of simple. So there was, on the day of the George Floyd riots, Prince William County, their police department, and they have a criminal justice sort of citizen council, had a meeting. And their meeting was at 10 o'clock in the morning, I'm guessing on the times, but their meeting was in the morning. And the chair of the board and two other board members decided to attend the meeting, the Board of Supervisors. It was a public meeting, but it was a public meeting of this other body. It was not the Board of Supervisors public meeting. What happened in the meeting is at some point, the Board of Supervisors chair physically took her chair to the front of the room and started talking. And so it became a Board of Supervisors public meeting. And while there's all sorts of arguments about the rules, I really think the physical act of her moving to the front and taking sort of control of the meeting is what wrecked sort of her being a citizen sitting in the audience. So if you're going to attend somebody else's meeting, just be mindful of the fact that you're not there in your capacity as a board member or a council member or EDA member. You're there in the capacity of a citizen. And if you're a citizen, you sit there and you don't be involved in the business, right? It's just a difference. And so they're trying really hard now to, as I've said earlier, to define the transaction of public business to fit this one. But you just are going to have to be really mindful of this, because the case is really not helpful to us, because we should be able to attend other meetings. I mean, the mayor's here, and I bet he's going to attend the EDA meeting, and he should be able to attend the meeting, and that should be fine. But this case has made it just really mucky if there's 2 or 3 of you that attend a meeting at a time. So I'll start with any discussion of public body's business by 3 or more members is a meeting, right? And people say, well, we're all going to go to the VML conference, or we're all going to go to the Christmas party. And my advice is put a sign up that says 3 or more members of council or of the EDA are attending a meeting, or attending whatever event. There will be no transaction of public business. So it's very clear that if you're all seen there, you're not there to have a private meeting about public business. You're there to have fun or run the parade or whatever event it's going to be. But that's a really important piece at this point with this case out there, to make sure that you say, we're all going to go here. We're all going to ride in this van or whatever it is, but we're not transacting public business. And meetings include work sessions, and they include other informal gatherings. So I think you have to be really cognizant of that at this point. It's Gloss versus Wheeler. And the Supreme Court, if you go on their opinions page, it's right there. So telephone or video conference meetings are generally not allowed. We're going to talk about electronic meetings later. There are so many exceptions right now for electronic meetings. The biggest thing is, if you're going to do electronic meetings, you need to have a policy in place. The Virginia FOIA Council has a draft policy on their website. They have a 2023 electronic meetings guide. It's painful to read, but it's probably the best guide out there about how you can make your electronic meetings policies if that's what you'd like to do. And that does allow for both remote participation in all electronic meetings in certain circumstances outside of the pandemic and outside of the governor's state of emergency. There will be a bill this year that's going to talk about disabled people attending board meetings and that they will be counted as a quorum if they want to attend a board meeting remotely because of their disability. And so I think that will actually be a bill that we'll get through this year. What does not qualify as a meeting is the gathering of employees of a public body. 2 or more members of the public body if they're at a function where there's no purpose or transaction of public business, again, the parade or whatever other events you have. And then at a public forum or a debate where you're to inform the public, and again, not transacting public business. That's the biggest part of it, is if you're going to go out there and debate something and make a decision or make a council decision or an EDA decision, that's where you just don't want to get caught with 3 of you in the room. I will tell you, it's funny, I was talking to the City of Alexandria attorney earlier today. They actually, before their council meetings, they stand in the hallway, the council, and 2 of them go into the manager's office at a time to get their briefings. And she said it's so weird because they just have found they like to stand in the hallway and do it, but it still looks like they're all together transacting business, right? Because they're talking in the hallway. So I'm not sure that's the best way to do it, but you can go in 2 at a time. There is nothing wrong with going in 2 at a time. So I just mentioned that to say that was a weird one on me today.
Sorry, another question.
Yeah.
The sign that says, yes, we'll be there. No, we're not doing public business. Where would that be?
It should go on your, do you have a signboard out here?
Yeah.
Yeah, should go there.
Okay.
2 or more included.
Yes. The mayor always counts as a quorum. Unless it's in your charter differently. Yeah. Yeah. So I'll just go over electronic meetings briefly. Electronic meetings are a lot. Remote participation by an individual member, you can do that if you have a quorum of the body present at the same location. Again, you have to have the policy. You have to describe the circumstances under which remote participation is allowed in your policy and the process for making the request. And a member may not use that due to personal matters for more than 2 meetings per calendar year or 25% of the meetings held, whichever is greater. So it's really 2 meetings a year. If you're going to be in Florida for the winter or whatever, you can participate twice if you have that policy in place, if you have a quorum in your town hall. You have to notify the chair in advance if there's a medical condition or if your residence is 60 miles away. Yep.
May not use the word participation. So that is that for every governmental city body?
So it's only for, it is for everybody. It's the advisory council. The advisory boards can do all electronic meetings. Everybody can do this if you have a policy in place. Yes. And then if you have a disability, then you can obviously talk about that and you can participate remotely if you give notice of that. It has to be recorded in the minutes that you're participating remotely, and the remote location has to be you have to be able to be heard, and you have to be able to respond. So you just have to have some sort of communication device that works both ways. For all virtual public meetings, now that's all public bodies except for local governing bodies, school boards, planning commissions, zoning and appeal boards, architectural review boards, and boards with the authority to deny, revoke, or suspend a professional or occupational license. So y'all can do remote meetings. Again, you have to have the policy, you have to describe the circumstances under which they're allowed, and then you can't do it more than 2 times or 25% again, and it can't be consecutive. So, like I said, public meetings are a lot. They're a pain in the, electronic meetings are a lot. It's really a complicated process still. I think someday they'll get there, but it's just going to be a process for a while. So again, all meetings are open to the public unless a specific provision allows for a closed meeting. Public includes the reporters, photographers for media that circulate in Virginia. And any person may photograph, film, or record a meeting. that's required to be open. Now, what you can do with people that want to record meetings, including the press, is you can designate an area where they have to be, as long as you treat them all the same. So you can say anyone who wants to record a meeting has to sit in, this particular section. So you can do that, but you can't say, that person can sit back there and this person can sit up there. And you have to put them in a position where the recording is reasonable, right? So you're not going to put them behind the pillar. So just something to keep in mind, but that's how you can sort of regulate that photography and taping, is if you designate an area where that can be done. In-person access. So this is another case. This is my Suffolk County case. It's one of my favorite cases. This lady, the lady that filed this case has been a pain to the Suffolk School Board for years. And so they decided that they were going to have a meeting in this room and that she could sit in that room. And they said, no, it's an open meeting. And the way that, if you read the case, it sounds like there were 6 chairs here and there was all this room like this. And they told her she could sit in the next room over. You can't do that. Okay. Let's just be honest. Like, that doesn't work. So you have to, as long as you fill the room and you have an overflow room, you can do that. You can say, okay, we have an overflow room, right? But you can't say, oh, we don't like you, go sit over there. And we're going to stream it for you. So just keep that in mind. I mean, this case was, I don't know why we had to go to the Supreme Court on that one, but we did. So thought that would be common sense by now, but anyway. So that's just a funny one that's out there, but it is something to keep in mind. Like, if the room is fairly full, you can move people to an overflow space, but you can't, discriminate and say, go sit over there. So meeting notices are really important. You have to notice the date, time, and location of any meeting. A public body must be posted 3 days before in a prominent public location, which I think is the board we talked about. At the office of the clerk or the chief administrator, and on the body's official website, if you have one. Ironically, there's still some people that have Facebook only. So the exception to the 3-day rule is for special or emergency meetings, which you have to provide reasonable notice, but you have to provide the notice of the special meeting to the public at the same time you tell the council or the EDA. So what's odd about that is, I'm going to call you and say, hey, are you free Tuesday to have a special meeting? But then I have to tell the public, almost immediately. So it's a really tough thing to do. So what you need to pull everyone sort of separately, right? And then once you decide and say, we're going to confirm this time, you confirm the time with the council and the public at the same time. Continued meetings now require a repost. Yeah. Oh, sorry.
Last time we adopted the schedule for all next year, the council did what
Yep.
all our meetings can be. We still have to post the meeting if they're scheduled in advance for every council, the 3rd, 4th month.
As long as you post the schedule for the year, you're fine.
For all.
Yep. Yeah, as long as you post it for everybody. Yeah. No, as long as you post this day, this is the year. And does it say something like if inclement weather, you go to the next day or something? Okay. Right. Yeah, no, as long as you post,
that.
yeah, as long as you post that, you're okay. Yep. Yep. So the continued meetings are the next thing that got caught up in a couple of years ago that are now required. You have to repost the notice. So what happens in the past is these boards would start going and they would get into this contentious issue. It'd be 10 o'clock at night. And they knew that the citizens out there were all going to go to work the next morning. So they'd say, let's continue the meeting to 9 tomorrow morning. And they didn't have to give notice. So the people that had left that were upset about the issue, or the people that knew they had to go to work, kind of got stuck because they couldn't give their public comment. So now you actually have to post that immediately. So if it's midnight and you go to 9 a.m., the clerk has a duty to go back to the office, post it, and also send it to all the people that have requested a notice of every meeting for the year. So you have to go back and sort of fix it, if you will, at this point, which is probably the right thing to do. And again, like I said, I just was talking about Virginia citizens and media can ask the clerk to tell them notice of all the meetings. And so they can say once a year, I would like a notice of every meeting that you have. And then the clerk has an obligation to keep that list and send it out every time there's a new meeting that occurs. And they can also request the agenda and, sort of the documents that come along with the agenda that aren't closed session documents. There's no general requirement for newspaper publication, but as long as if you have the notice, you should publish it. The whole list for the year. Other public meeting requirements, you can't vote by secret or written ballot. You have to keep minutes, which are public records, even before they're approved by you. Minutes do not need to be a verbatim transcript of the meeting. So let me say that. Do not transcribe your meetings. It's just, it puts you in a bind, and you're better off to keep your minutes consistent with the date, time, and location of the meeting, the members recorded as present or absent, a summary of the discussion of the matters proposed and what action was taken. And then if it was an electronic meeting or if someone participated electronically, that they did that. But that's what your minutes need to be. They don't need to be comprehensive stories or anything like that. They just need to be those things. And that way you can be consistent in each different board and council or commission that you have, so that they all look the same. Audio video recordings are not mandatory, but if you have them, you have to keep them because they become a public record. And so that's something to keep in mind too, that once you record that meeting, it's a public record and you have to hold it under, and I will tell you, there's a state, I'm sure most of you know, but the state library has a record retention schedule, how long you have to keep various local records before you can submit them for destruction at the state library. The minutes should be posted on the website within 7 working days of final approval. If you do not have a website, you can make copies of them available. But again, you have to provide those minutes somewhere public 7 days after they've been approved. Official government website. The town of Pound. I don't know how many of you know where the town of Pound is, but it is out on the Kentucky border. Great story is a couple of years ago, they got in trouble because they were citing speeding tickets only to people from Kentucky. And the judge actually ordered them to put on their website an apology to the Kentucky drivers. So, but the town of Pound also is known for defining an official government website. They have a website that's done by one of their people, and it's pound.something.org or whatever it is. I don't remember what it is, but one of the attorneys in their town argued that because it wasn't .gov, it wasn't an official government website. Well, the court said, no, let's stop that. That's just dumb. And they said the internet site controlled by the public body that the public body puts their information on is an official government website. So just know that the town of Pound is infamous for 2 things. And if you want to read about them, the Washington Post has a great story about them. They only because it's just as an aside, they were really in trouble a couple of years ago, and the mayor was really struggling. And so the Delegate Kilgore, who's their delegate out there, put in a bill to take away their town charter, which is really not cool at all. And so I begged him, and we finally signed an agreement with them to do all this training. And so last year, he and I were able to get up, and he said, I'm not going to take away their charter. So it was really exciting to fix it. And the Washington Post story is really great about how they figured it out and really came back. But that was a scary one. So, all right, closed session. So back to our discussion from earlier. Personnel matters are almost always closed session items. You can interview candidates in closed session. You can do promotions, demotions, talk about individual salaries, disciplinary matters, but it has to be about specific people, not general policies. There's an attorney general's opinion that says that you can only go into closed session on personnel matters that are your personnel. So depending on what your charter says, if you're only managing the manager, then you can't go in for anybody else that's not your employee, because they're the manager's employees. So you have to be careful about how you're going to go in. Now you can go into closed session and talk about the personnel overall for the county or for this town, and about how you want to change the, sort of the family tree or the, sort of the hierarchy, but you can't go in and talk about an employee's behavior that's not an employee, that's your employee. So you just have to really be careful about that particular thing. Consultation with legal counsel, you can go in on into closed session. It's a catch-all. People try to use it all the time to say, oh, we're going to go in on, under legal, and we're going to talk about things, and then their counsel is not there. Well, that's not really the right way to do it. So be careful when you go in. You really need to have something. It can be potential litigation. It can be the purchase of property, bargaining about a business, or bargaining about something else. But you have to have something that really relates to a legal process that you're going in to discuss. Yes.
I'm a member of the EPA, so if there was a negotiation on loan documents, would that be closed session?
So that's the next one, right? Is it property? Yes. So If you're going to discuss real property, acquisition, disposition, where the discussion would adversely affect the bargaining position, absolutely. It's a closed session item. And if you're going to talk about negotiation strategy, absolutely, it's a closed session item. And you should go in and talk about it, and then you should keep no records and walk away unless the manager keeps, working papers, because he could take notes there and he could call those his working papers as long as he doesn't share them with anyone else.
So has to do with personal finances of property owners that the EDA would be lending money to, that would be subject to closed session with the EDA's attorney.
Yes.
And what if the attorney's not there? What if you're just negotiating directly with the borrower? I mean, I wouldn't do that.
Right.
I would say that's bad to do, but
So if you're negotiating directly with the borrower and it's somebody's personal finances and it's something that the public could figure out who it was, then I would argue that it comes under, there's another section that it's not on our slides that's talks about discussion of a prospective business or industry or expansion of an existing business or industry. And I think that's where you would go, is you could argue under that code section. Or there's a second one about discussion or consideration of investment of public funds where competition is involved. And that one also, I think you could use that section. It's always better to have your attorney there. So if you look at page 51 of the book, yeah, really, your sections that you want to look at are really from 3 to 8. Those are the various code sections that I would try to go under for this particular situation. There's another section, and I had meant to bookmark it and I didn't, but there's another section on economic development, but it really talks about if you're involved with VEDP. And I don't think, I could be wrong, but I don't think VEDP is involved in your project. Are they? The Virginia Economic Partnership? Yeah.
I don't think so.
So I think the other section belongs to them more than, yeah. But I'll find it before I go, so I can apologize, I didn't bookmark it.
Sorry. but
No.
I guess. Question audience. So you just recap that little question real quick since the mind.
Sure. So her question was about going in about a private person's finances when the locality might loan them money. And I suggested that there were some exemptions that you could look at on page 51 of the book, but also I think there's an economic development section that I did not bookmark that I said I would find before we leave. Does that help? Okay.
And also, I'd like to clarify, Rosemary, what your question was, and Michelle, what the beginning of your answer was. Because it sounded as if Michelle was answering in terms of that the EDA would be buying property, and that's not my understanding of what the negotiation is.
I was speaking of the loan document subject to financial consideration.
Right.
I think that under the EDA, I think they can purchase property. I don't think anything's remotely contemplated at this point. But I think that there are sensitive financial negotiations.
Sure. But I just wanted to be sure, Michelle, since your answer started off with sounding like that the EDA was going to be buying property and that was what the negotiation was, just to sort that through.
Lending money, yeah,
For the purpose of buying property?
not for the purpose of buying property, of rehabilitating property.
It's the IRF grant.
Yeah. Let's talk about it, maybe offline, maybe better to talk about that one. Okay. So to go into closed session, you have to have an affirmative vote in an open meeting. You have to identify the subject matter and state the purpose of the meeting and make a specific reference. So if you go into closed session, it would have to be, it's the I'm just thinking out loud, the bargaining of grant funding or the consideration of grant funding to various provide requesters maybe or something like that, but you have to be fairly specific so that you can make it, yeah.
Yeah, just to add, having been brought in Cape Charles into court on this,
Yeah,
the one thing that's, we've gotten beyond now is identifying the subject matter in your notice. You can't just say personnel matters.
no, you cannot, no,
All right, it's an important point that you have to
Yeah.
be more specific, although you don't like to. That's what we were caught on, is
Yeah.
not following that aspect.
no, that's correct. You have to say like, we're going in a closed session on a, it can even be as specific as the evaluation of the town manager.
Right.
Yeah, but you have to be pretty specific about what you're doing. Consideration of salary or consideration of compensation or whatever, you have to be very specific about it. And you're right, there is a case that says that. And then you have to, at the end, you have to come back and you have to certify that you acted properly in closed session. And so there's been many cases where someone will vote no. And as long as the quorum says you voted, you kept closed session appropriate, that's okay. But there are occasions when someone says, well, I think we went outside the lines, and then that just makes it funky before you get outside. So, maybe have that discussion in closed session, and you can pull the members back there. So you can know where everyone's going to go by pulling the members in the back before you come back out and certify the closed session. Minutes are not required. And again, you can pull the members, so I'll tell you, this is a terrible story, but we have one locality where one of the council members has been, he went to court the other day and he was convicted of a felony. And part of his conviction was that he can't leave the state of Virginia. Well, the day after, he decided to sign up for a conference in Atlanta and bought plane tickets and paid $1,700 to register him and his wife. And so that council went into closed session last Tuesday, and they went in closed session. They fought about it. They decided he had to pay half of it back. First of all, the guy has no money. I mean, he's in trouble for not having any money, for starting a GoFundMe page that he took all the money from. But anyway, so they went back into closed session and they voted to have him pay half. Hold the members is what you're supposed to do, right? And it was 4-1. And so the one lady she calls all the time and we love her, but she called me and I said, well, you can't direct that from the back. You have to vote in front. And she goes, well, they're not going to vote the same way in front. And I said, is that a bad thing? Right. So it'll be interesting. They were going to meet, I think it might be tonight that they're going to meet to vote in front about what they're going to do with his paying back the money. So I won't tell you where it is, but I'm sure you can guess. So anyway, you have to make sure that you certify the closed session. This is sort of the studying of FOIA. So what you have to do is, theoretically, within 2 weeks of your election or re-election or appointment, you're supposed to get a copy of a FOIA guide, no matter what. It could be the online link, it can be whatever guide it is. And then you have to designate a FOIA officer, and they have their contact information has to be made available, and they should maintain your training requirements, training completion. Sorry, I couldn't think of the word. You also have to post rights and responsibilities of your localities in plain English on your website, and then put a statement about the cost calculation, like I mentioned earlier. What you have to do with the FOIA training is you have to take it within 2 months of taking office and every 2 years after. The clerk keeps the records, and I'm going to tell you why the clerk keeps a record in a second, but that's a really important thing to know, is that your clerk should keep the records. Here's what happened in the state so far. The General Assembly members, you file economic disclosure statements, the General Assembly files them. The General Assembly files them with the state. You can go search them online. I can find any of them in 5 minutes and tell you how much money they have personally. We don't want you to have to do that. Like, if your clerk keeps that record, then the person that wants it has to come here and ask for it. Once we agree to let the state do it, then that's searchable online everywhere, which is horrible for any council and provides a huge chilling effect, right? For us to want to be on these different boards and commissions. So continue to let your clerk keep the records. There are a bunch of penalties. I won't go over the penalties, but I will say that you know, you should be aware that if you violate it and it's intentional, there are personal penalties that go along with FOIA. So if you have any questions about that, I can happy to answer them now or later. And then I'll just go to the conflict of interest briefly. I know we're on short time, but the Conflict of Interest Act is a whole different ballgame than FOIA. And I'll tell you, a couple things. 99% of the times that we think there's a conflict, it's not a legal conflict. It's a perception of impropriety. And that's more important and probably more significant to you than any of the rules in this book. So we can go over the rules in the book all day long, but it's the appearance of impropriety that's the problem, right? As soon as I see you talking to the landowner next door to my rezoning or whatever, that's when people say, oh, they're in cahoots together. So you really, I think you have to be really careful about saying, this is what the code says, but this is where I think that I maybe should be careful or should at least make a statement about what I did or what I was seen doing. For example, a couple of years ago, we had a developer in a county come in and he said, you know, I'm thinking about putting some property here or buying this property and putting something here. And he said, I'm just not sure. He was talking to one of the board members. Well, the board member went and bought the property next door. Looks terrible, right? But there was no official record of a request to do anything with either property. He just acted upon the information he had. And so it totally looks like a conflict. Everybody knew what happened. There's rumors all over, right? But it's not legally a conflict. He was okay in what he did, unfortunately, maybe. But that's the perception piece that's the problem in the Conflict of Interest Act. So there's three main goals in this act. One is to help ensure that the government will represent the public in its operations and not personal interest. The second is to give citizens confidence in public officials and government so they will trust us. And that is by creating a clear set of rules, so they say, and then to assemble all the laws in one place so that we have uniform rules. And that's really the most important thing, is that they want to make sure that everybody is operating under the same rules as far as the conflict of interest. The act regulates the financial relationships of council members in three general categories: general provisions covering bribes and illegal behavior, regulation of interest in a council member in business dealings with the locality, and then the level of involvement in an item being considered that involves official business. Bribes and illegal behavior are easy, right? You don't take them. Just don't do it. It's not worth it. Even if someone wants to buy you lunch, sometimes you know it's just not worth it because it's going to look bad. So you just have to be smart about that. The undue influence part is really hard because the gift rule is so confusing. And you're really better off to look at what's not a gift, because I think that's the easier part to look at. So what's not a gift is coupons or tickets that you don't use. Okay, fine. Campaign contributions that are properly reported, a gift that relates to a private profession or volunteer service. One of my favorites is food or beverages consumed while standing up at a party. So if you come to any VML event during the legislature, you'll notice that there's very few tables, because if you stand, you don't have to report the food. If you sit, you do. And I wish I was kidding, but I'm not. And then you can get gifts with $20 or less, and you can get gifts from a relative or personal friend, but then you have to define personal friend, which is really weird. But anyway, that's just part of the rule. So if you ever have a question where someone's trying to give you something, take the time to look at it. Now, it says that it doesn't apply to localities with a population of under 3,500, but if you have bonding capacity of over $10,000, it applies. So it's really sort of not written very fairly. Localities can adopt an ordinance that creates a limit on what your employees take as a gift. So sometimes it's $50 or $100. But what's weird about that rule is, so one of the things that we tell people is, okay, you get poinsettias, right? Somebody sends poinsettias for the clerk's office. As long as they're shared and they're left in the clerk's office, that cost is not directly to you. If you take the poinsettia home, then you're taking it as a personal gift. But if it's a gift for sort of everybody in the office, that's a different thing than taking it home. Same thing with like the turkey dinner. If you take the frozen turkey home, it's your personal one. If you leave it here and share it with everyone, it's not a personal gift to you. So there's a couple of things there's two sort of ways to look at council members' actions as a citizen. One is a personal interest in a contract, and one is a personal interest in a transaction. And then there's a bunch of exceptions, but here's sort of the short term. If you have a personal interest in a contract, it means that you own, the council member or EDA member owns at least 3% of equity of a business. They have annual income from the business that is reasonably or could be in excess of $5,000 or owns a property worth more than $5,000, has a benefit that could exceed $5,000 or the 3%. And sort of every one of them is 3% or $5,000. So just keep in mind, if you have something that's going to mess with your personal business and you think you're around that amount, you probably really do want to look into this code section and really study it or ask for an opinion. One of the big things in the Conflict of Interest Act is this, is if you get an opinion from your attorney, your town attorney, or the Conflict of Interest Counsel, and you rely upon it, that's evidence that's good for you in court. So if someone pursues it, you can say, no, I followed the rules, and that gives you some immunity, not all, but some immunity. So you want to make sure that you ask those two people to get that opinion. I'm sorry, it's not your town attorney, it's the Commonwealth attorney. It's Commonwealth attorney or the Conflict of Interest Counsel, sorry. It's late night. But that's something that's really important to keep in mind. There's also all these things about immediate family, and immediate family includes people that live in your house. So if it's not your exact immediate family, it's also people that live in your house and that get benefits from you, so food or whatever. So just keep in mind that you don't want to get in a conflict with those people, with people that live with you. The exceptions to the conflicts and contracts are that you can be an employee of the locality as long as you began your employment before you were elected to council, which is kind of weird, but that's what it says. You may buy goods and services from your locality as long as they're made available to the public at uniform services or uniform prices. So t-shirts, flags, whatever you need to buy from the locality. And then you may sell your goods to the locality if the purchase must be made by competitive sealed bidding, or it's for goods, not services, and the goods have been established prior to the person's coming on council. So for example, if you were the newspaper provider in the town and you were still providing the newspaper after you got on council, that's okay. Or for example, if you need a tractor and they own a tractor dealership and they had bought tractors prior to that, that's okay. You can continue to have that business. If they want to sell to the locality after they're on council, then they have to play no role in preparing the specifications for the purpose. So then you sort of have to walk away and let your partners in your business do that. And it may be right that you have to also disclose the 3% or $5,000, depending on if you have those interests in it. It does not apply to providing services, but it really kind of does, because you're still going to want to have that Chinese wall where you're not the one providing the services. So particularly auditing services and things like that. You can technically enter into that contract. It should be by competitive sealed bid, so they don't know that it's you. And it should be done by another person in your firm, but there is some authority to be able to do those sort of services. I'm trying to skip around. Sorry, I'm trying to get through this because I know we're almost done. The disclosure. So let me talk about disclosures. That might be the best thing to go to next. Disclosures are hard, right? So when you're in the meeting and you know that you have an interest in something that you're going to vote on, you should physically remove yourself from the dais. You should say, I have a conflict because of XYZ. You get up and you go sit in the audience. You don't participate in the debate. You don't participate in any of the vote, but you physically move yourself so that you're not sitting up there showing that you're trying to put any influence on the other members of the council. And that's really important. And then you want to make sure that the clerk documents that in the minutes so that you have a documentation that you said that. Same thing goes for the appearance of impropriety. I mean, if you really think that someone's going to say something or that everybody in town's been talking about it, then you might want to say up there, I don't think that I have a conflict and I'm going to vote, but here's why. And just put it in the minutes so that you've been very clear about this is why I think I can vote or this is why I think I should not vote. I'm sure you've been through all the forms. The forms are no fun, but unfortunately we have to do them. And the Conflict of Interest Act is really, I went to their meeting the other day. They meet once a year and I was the only person there. And what they said was, they got up and I said, I really need you to do some conflict of interest counsel training for my members. One of the things that's weird is FOIA counsel I can get that approved by Eric Gregory and you're good. Under conflicts, you're going to have to watch the video no matter what, or you have to go to online or to the in-person training. Well, they don't do in-person training from January to May. And so you have 2 months to get it done. And I don't think you can get it done in that time period if they're not doing the training. So I did offer to put in a budget amendment to try to get them a new attorney so that we can have training in January next year. So for now, you're going to have to watch the video, which is not helpful, but it is required every 2 years. And so take the time to do it so that you can give the clerk the confidence that you did it. But just know that that's a really weird thing in the law. And with that, I'm happy to answer any questions or go into conflicts, but I feel like I should take questions.
I have one with regards to you, if I'm on council and I feel I have a conflict of interest, I can remove myself?
Yes.
Or do I have to declare and have the others agree? Because there was some confusion about who removes that particular person.
No, it's your personal decision. It's not the council's decision. It's personal.
Question.
Yeah, sorry. So the question is does the council decide that you can remove yourself for a conflict or does the person do it? And the answer is, I believe it's the person because you're declaring your own conflict and you're taking the time to say, this is my conflict. I'm not going to be participating in this vote. Now, you can't force another person to do that. There are times when you might think another council person should do that. Unfortunately, that's not your role. It's the role of the attorney to say, hey, that based on the facts that I was given, this seems like it could be a conflict for you. Why don't you get an opinion from the Commonwealth Attorney or the conflict counsel? Yeah. Any other questions? Yeah.
Um. So page 21 says, section 4, note, restriction of 2 meetings or 25% only applies to personal matters. So what's that saying is that, and I'm asking this because I've been on council for 5 years and I missed 2 meetings this year. So I can only do that for 2 meetings. I can only attend remotely per year.
Yeah, if you're, yes,
Yeah.
2 or 25%.
So if I'm unable to attend a meeting, then I'm just not there.
You're just not there. That's right.
Now, in EDA, it says that if you miss 3 meetings in a row, then you leave the board, right?
That's probably what your rules say.
Yeah, the bylaws.
Yeah.
Yeah, okay. And then also, one last question. In EDA, and I just wonder if this is the same in council. There is no proxy vote,
No.
which means you cannot vote by video.
Well, if you have an electronic meeting policy and you follow the 2 meetings, you can. But you have to have the policy in place.
Okay, you
Yeah.
have the policy, so yes, you can vote by video.
Yes,
And does your participation by video count in the quorum?
it does kind of in the quorum, except for, yes.
Okay.
Yep.
thank you.
That's draft.
Oh, sure. So, there's a question.
Okay, I have a question about draft materials.
Sure.
Because it said that our draft materials were subject to FOIA. And but also I know that, for example, our minutes need to be posted 7 days after they're
Yeah,
adopted.
approved.
So like our agenda and our minutes and things are submitted to us in advance of our meeting. They're put on the town's website, but they're all in draft form because we haven't voted to approve that. So I'm wondering, how should we finesse that?
So draft minutes are hard, and I think draft materials are hard, but they really are, no matter what, subject to FOIA. So I assume you're voting on your agenda at the meeting to approve
Mhm.
the agenda.
Mhm.
That's the hard part. I think you just have to mark it as draft and know that it's
Good.
out there and available.
Okay.
Those are the hard ones. Yeah. Okay. Anything else? Yep.
Being dense about this.
No, you're fine.
So does this session take care of our FOIA training?
I will talk to Eric, but Eric knows I'm here. And so, yes, I think Eric will say that it does. Yes,
But you have to go online and. do
conflict.
FOIA
Yep.
training,
Yes.
And then you have to tell somebody that we did that.
That will generate a certificate at the end, but you have to go to the very end, but it'll generate a certificate and then you give it to the clerk. Yep. Yep. All right, thank you.
Thank you.
Appreciate it. Thank you very much.
Great.
Thank you.
Thanks, everybody.
Well, you know, that's what this is. And I wanted to ask you, what is this? I didn't print out the pages, but statement. It was with EDA. And basically you have to, this is what you had to do.
No. I got some time off. And everything. I would have to walk around and see kind of what I need. I bought them.
Well, that was interesting.
Yeah.
There's a place down.
Joining it. Yeah.
I think I stayed with the EDA.
Yeah.
So Katie, Steve and I were just talking about this. I'm trying to think where I got this.
Huh?
I think I got it.
That's the question.
This is like a 20-page document. It's EDA related.
If you guys figure that out, let me know, will you?
Oh, this is what the COIA.
You think that's what it is?
They'll walk us through that.
Okay, all right.
Can't wait.
You know, where do you get the online training information?
The town clerk.
I guess it's the town. Yes.
Okay.
You know what I was interested in, do you have a conflict of interest?
All right.
If they got you, they can make it as long as they want.
I just wonder what the penalty is if you don't do it,
Right.
because I know there are people that haven't done any ever.
I know, I've heard.
Yeah.
But I asked Matt.
Well, I usually go to the VML conference and our attorney, Eric Gregory, gives the training, so we're covered, but I know that there's,
All right.
I'm sure.
Ability, I understand, because everything is so out of control.
Sexual harassment, so much.
For.
Spend a lifetime doing
Yeah.
Which is a good thing on the one hand, but it takes the time away from what you really need to get done. Well, I like these new bylaws that we came up with. Yes, they're readable.
Yeah.
They're understandable. Yeah. Yeah. Yeah, I got the message tonight.
Yeah. And I made what Jeff had proposed. And then I just made notes to try to make them like more like. What work reading right here.
If it shows
That.
I did to go.
Oh, it's hard to do this right now,
Yeah.
right before the meeting, but I'll.
No.
Set the.
I think we could try to do more like. Right.
Yeah.
Not over.
Resolving.
She didn't move herself over there. She got up over here, just like everybody else.
But you mentioned.
She did. Okay, I mean, that's what we want to know.
See, because.
You say you want to hurry, you may.
Yeah, like, I mean, let's see.
Maybe some
minutes
before my test,
and it's.
We're interested.
Closer to the thing and the.
Yeah.
So I will get this one.
These are very complicated.
So I'm worried about production on that.
The school.
Yeah.
Yeah, I just pulled that.
Yeah, what
We've got 20 minutes.
Yeah.
Is that something you're gonna send out? Notification of where it is and how to do it?
I'm coming in late. What's the question?
The COIA training. She said the town clerk would let us know where we can access it. Yeah.
Okay, so there's.
I'm happy to know all of it.
She's very consistent. Yeah.
Which is.
Yes.
Without going over the audio, you know, the recording.
Yeah. Well, whatever it's like.
Online.
Figure about it.
No, I don't think we should.
Yeah,
Actually, I really want to go hearing about.
That's fine.
Yeah, no.
Greg is not there and.
No, it's not there. It's right. Hello.
But I won't have the classes yet.
Wow. I think our names on the back of the map, but it was two.
I also
Knew that. It was fun to look at that. It would be like that. Yeah, it's in there.
Yeah, but I made it a little more.
Oh, yes. Be safe.
And then go.
Thanks.
Right.
It's like, yeah,
I just couldn't remember.
Safe drive home.
In school. Enjoy my.
It wasn't in the original. I should have the. Maybe if I don't see you.
There's just something coming on your page. I see something
Santa's.
fluttering.
Santa's, yeah.
Santa's now.
Well, it's there. The hands are worse.
I think you're wearing the Santa hat.
Okay.
I got it.
Yeah.
Oh,
yeah.
Well, the wind has been bad.
Yeah.
The new town.
That's
cute.
Yeah.
Oh,
Yeah. Because that's what we want to.
I love her.
Yeah.
Yeah.
I know. Very large. It's funny.
Well, thanks. All right.
You know, I don't know about EDA. Heard it, he wasn't the same.
I saw that.
Yeah, look at, I think this one's better, right?
Yeah.
It's 29. Okay, thank you. And then.
That's you too.
Thank you.
Good show. Here's your coach.
Oh, yes, thank you.
Oh,
Thank you, Michelle. Thank you. Safe trip.
yeah. I heard it. Yeah. Right. Although I like the police chief in Eastfield, they call me all the time. So. Talking about it.
Good. Oh, good, okay. Yeah, I did a little, meditation, so I can do it something more like the town.
Great, I love, and I used to work for.
Oh, really? That's fantastic. Yeah, Jeff really good. I'm hoping I can find it.
Yeah, it's crazy, right? It's so interesting though. January, right? Yeah. Really. Good. Well, yeah, let me know if I can help you now. Yes, it was nice to meet you. You were here. What other side about it? All right, wait, yeah, come on in. We have pizza, y'all want? No, we're good. Are you sure? Okay. I promise. You got the promise. Thank you very much. Thank you. Take care. Happy holidays. Can we carry it?
Did you get a chance to talk? We talked?
I did. I gave her the page. Next time y'all are gonna do this.
Did you talk about the attorney?
At our house. Yeah, let me do that. So sweet. I couldn't remember what it was. I said I couldn't remember what it was. Yes. Thank you. Yep. That's a sincere offer next time. Well, I'm gonna take you up on it next time.
All right.
Yes.
Really? So where's your college? Where in Montana?
Bozeman.
Oh,
Yep, so about,
beautiful. You like to ski or something?
I love to ski.
Oh,
We have a ski hill 16 miles from campus.
yeah.
We have a free bus that goes back and forth, so. It's
So
awesome.
you're a freshman?
I'm a sophomore.
A sophomore, okay.
Yes.
So you made, you know, you have to.
I'm majoring in business management.
Okay.
Yeah.
Sorry.
So where, are you from Richmond and now you go to college out there? Or you
Yes,
from
ma'am.
out there?
No, I'm from Williamsburg.
You're from
and-
Williamsburg?
Yes,
Okay.
and,
Michelle, Williamsburg?
we live in New Kent County, like right in between Richmond and Williamsburg.
Where'd you go to high school?
I went to New Kent High School.
Oh, you did.
I
My
did.
sister taught at Long Hill.
Okay, yeah.
So, yeah.
They were, one of our most difficult tennis opponents. We played
Oh.
on yeah, but, yeah, so I grew up there and then now I go to school in Bozeman.
How did you find Bozeman? I mean, what drew you to it?
Yeah, it's really funny. So my mom had a conference out there. So we all went out there and I was like, I have to find a school here. It's just so
It's a
beautiful.
pretty neat place.
You found your place.
I did. Only school I applied to, got in and
Oh,
haven't
yeah.
looked out.
That's great. Yeah.
We went through, yeah,
We
Glacier
stayed
National
at
Park.
Kalispell.
Yeah.
Oh, Glacier's beautiful.
And it's pretty, yeah, I've spent other time, I've been in Wyoming several times. but it's been really,
Thank you.
much in Montana. Usually it's supposed to be-
I'll tell you, our winter's been crazy mild this year. We've had practically no snow.
That's not gonna be the trend, right?
I hope so, but also it's nice to not bundle up in winter coats to walk to campus and, but I ski at Bridgerville. So it's a small town, little
Yeah,
ski
big time,
hill.
big time. See all the movie stars skating, right?
Yeah.
Really, please let us know if you're gonna come and visit all the time.
Yeah, I guess.
I appreciate it, because I thought about staying and then just.
Yeah, we got a nice little guest house.
That's very nice of you.
Safe drive.
Thank you. It was nice to
Yeah.
talk to you.
At least
I
you're,
told her I'd send her some names.
Okay, great, thank you. Okay.
at least the HRBT will be quiet. I know.
And that's what I figured.
Yeah.
Yeah.
We'll get through this.
Yeah.
We're gonna have sushi on the way back, right?
All right.
Take care. Thank
Bye,
you.
y'all.
Nice to meet you.
Hey, the meeting can't start at 6. 6. They're eating pizza back there.
have a problem back and forth, that will fall apart. It's going slow. She's considered a narrow area. She's going to find it one foot at a time, going in that direction at a time. My brother is now probably.
Thing of life, you could, yeah, you could have where and God and right down there. Right hand side of that bridge, right, that went over, that's literally across.
Maybe we should move to a more comfortable seat.
Not that comfortable now. That's not a model.
She's that.
It's like.
But all the streets.
And I felt like, why are you so much?
Avenue.
Why are you looking for things to make, you know?
The road system that goes. Somehow.
Yeah.
Just as the sounds.
I felt like I was starting to sing. And I would sing. I don't like how it sounds.
One person.
But she's poisonous. And you honestly think you're making me bad. I don't know. No, she's been a little more different. I've been pretty.
And then next to that. Well, that was their house. Situation. Also. It goes down.
We call it paper road. We have a lot of.
Yeah, a lot of people, bro.
Yeah, there was a footbridge.
Right, you don't remember people that came over to the coach
Yeah.
where there was a school.
Where was the beach? I read about it a lot, like Shorehorn, with the undesirable name.
Should be.
Yeah, that one.
Really?
Yeah,
That's hilarious.
that's when sewage flowed freely in town.
Oh, wow.
That's right. Right there. And you know how it got its name? Yeah, back when I grew up over there, every one of the houses had a terracotta line that ran down the creek. That was the Hancock. So was and so as a kid, we would on the creek, there were little paths all over. They weren't really paths.
But sadly, it's still true for us. Yeah, unfortunately, here in the Nantucket.
They're extending it. Watch Creek up that, that's one thing. And
Contractors, the watch big, that's gonna happen.
I saw the light up there.
Thanks, man.
But I'll get the fight, because they're awful lot of people that want to make that happen.
I was aware of your father. Right down there.
What was interesting when that first discussion started, they didn't want to have any hookups. with residential. Now that everything's going forward, but it's, I've got sea level rise, high water table, I've got well, I've got septic tank, all on the same property. That's practical. Okay, your septic
hey. Hello, Fletcher. How are you? I am good once I got the door closed. Yeah, I know. I told about the problem. All right, nice to see you. You're doing all right, all right. How you been? I can't complain. Actually, Janet's sitting there. Oh, all right. Yeah, they're back eating dinner right now. It was finished up with the FOIA and, training. They got an hour and a half of COIA training that Michelle got. A very encouraging.
You know, it's always better to do that live.
Yeah. Well, it's Michelle. Is that, I don't know if you met with people that are-
No, people like her.
Well, she's the executive director of BML.
Oh, okay.
And also attorney.
Oh.
And she's.
Oh, Janet, how are you?
Don't my stuff in your way.
No, that's fine. I am totally good. You're doing a smooth thing.
So, yeah, that was good. They were any questions, about specifically about, what the EDA is doing about. They could talk about it, and then you.
Yeah, exactly.
In the closed session, not discuss.
Oh, yeah.
Personal details.
There's a lot to it.
Yeah, so.
You know.
So what do you all do for Christmas?
Well, no, we're, things are kind of piecing together a little bit.
Nice.
They're just so we're going up to, Philadelphia. Yeah. So.
Nice way to end the year.
Yes, yeah,
Well, give that big platform.
I sure will. I sure will. She's,
So fun.
yeah, she's actually doing well.
You gonna leave when you started?
I always want to hear
Who's
about
gonna
it.
lock up?
You know.
I'm coming back. I'm coming.
Dylan, so
Who's gonna
look, you know,
check?
my.
You can lock this door if you want, because I don't know how to text.
Keep her in check.
She better, she always gonna text me.
You got that right.
She's always gonna text me.
You got that right.